Hi guys, good evening and welcome back to Gradeup. My name is Harshmeet Singh and you're watching me live on the Gradeup IAS YouTube channel. I hope all of you are doing good and I hope all of you are in the best of health. I thank you all for joining in once again. This is class number 5, the last class of this 5 lecture mini series. As you know, this week from Monday to Friday, we decided to do a mini series in which we would be covering the higher judiciary of India. So far, we have covered the Supreme Court, the High Court. We have also covered in the last class the issue of the pending cases in the court, and now we will be going ahead doing our last class in this mini series about the concept of PIL and the concept of curative petition as we see in our course. So this is what we are doing. Thank you so much for joining in. Hi Manish, good evening. Always good to see you. If you have just joined in, make sure that you do like the video or share it with your friends. Subscribe to the Gradeup IAS YouTube channel also if you have not done so till now. Without waiting any further, let's begin and start our class. We'll start first with the concept of the PIL. Now, PIL stands for Public Interest Litigation. Now, what exactly is this? See, usually in if you have to file a case in the court, you can only file a case in the court if you are concerned with the case, if you are connected with the case. Means if you are a locus standi. That's a pretty important phrase. Locus standi means usually the court will only accept a case if you are related to the case, if something wrong is happening to you, if you are concerned with it. You can't just fight a case anything or just because you have to. Hi Chandra, hi Chiku. Manish, not my class, at least I don't know what anyone is. So, the concept of locus standi was that you could only file a case in the court if you were related to the case. PIL, however, is not the same. PIL means public interest litigation. So, PIL means you can file a case in the court even on behalf of the public. Even on behalf of the public, you can go ahead and file a case in the court. This is what we mean by the concept of PIL. For example, let's say I know that in the jail, police is not treating the people well. I am not in the jail. I don't know anyone who is in the jail. But still, because I know the people in the jail are not being treated well, I can go ahead and file a case. This will be called public interest litigation. Public interest litigation is not written in the Constitution of India. There is no law about public interest litigation in India. Public interest litigation is an invention of the Supreme Court judges. So, judges in the Supreme Court, for example, there have been two judges related to it, Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. There were judges in the Supreme Court that themselves have started the concept of PIL. The concept of PIL is not mentioned in the Constitution. कहीं Constitution में mention नहीं है. There is no law about it. It is just an invention of the Supreme Court judges. Hi Rajput, hello Chandra, hi Pragya. Good evening to all of you. Very happy to see that all of you have joined. So, as I said, public interest litigation is an invention of the courts. That is why it is called judicial activism. Now, you can file a PIL in the court, but it is upon the court whether the court wants to accept it or not. Whether the court wants to accept it or not, it really depends upon the court. Now, the meaning is when you go and file a case in the court will hear it obviously. But when you file a PIL in the court, it depends whether the court wants to hear it or not. Getting the PIL heard is not your right. It is a decision of the court whether the court wants to accept it or not. On the other hand, the court can also take up this case suo motu. The court can also take up the case suo motu. What is suo motu? Suo motu means apne aap se, by itself. For example, if no one files a case in the court on a certain matter, let's say pollution related matter. For example, abhi on the vaccine policy of the government, the Supreme Court time and time again started saying that the government is not working well. That was not a case filed by anyone. The court itself, suo motu, took up this issue. So the court itself can take up the matter even without anyone filing the case in the court on such matters. Now, PILs can be filed for all these reasons. If there's a bonded labor matter, someone is being forced to work, neglected children, children not being taken care of by the parents, non-payment of minimum wages, atrocities on women, environmental pollution, adulteration in food, maintenance of heritage and culture. All these are cases, or all these are examples in which PIL can be filed. PIL can be filed in all these cases. As I said, if you look at the history of India, the concept of PIL is not written in the constitution, it is not written in any law. There were two famous judges who started the concept of PIL in India. One, Justice V.R. Krishna Iyer, and the other, Justice P.N. Bhagwat. They were the ones who started this concept that anyone can now file a case even if it is not related to them in the interest of the public. In 1979, there was a very famous case called Hossainara Khatun versus the state of Bihar. The case was about the fact that the government is not taking care of prisoners. The people in the prison are not being treated well by the police, and whoever is in the prison, we don't really pay attention to them. So a case was filed on this issue. The court heard the case, and the court gave an order to release a lot of people who were in the prison, who were under trial. About 40,000 people who were under trial were released from the prison on the basis of this PIL. Now, the person who filed the PIL was not someone who was in the jail herself or himself. It was a PIL filed in the interest of the public or someone else. Apart from that, as I said, Justice P.N. Bhagwati also took ahead this case, or took ahead this issue of PIL. Again, those who just joined in, usually when you file a case in the court, you can only file a case if you are related to the case, if you are concerned with it. But now the courts also offer, or the courts also allow PIL, public interest litigation. Public interest litigation means now you can file a case on behalf of public as well. On behalf of public as well. Anyone who thinks that it is for the betterment of the society can file a case. Now, you can file a case in the High Court also, or in the Supreme Court also, but whether the court will accept your PIL or not depends upon the court. Also, once the court accepts the PIL, एक बार court ने PIL accept कर लिया, then it is just a usual case. फिर कोई special treatment नहीं मिलता. There is no special treatment for this particular type of cases. It is just, the only difference is who can file a case and who cannot. Since then, there are many other cases which have been famous in India and were filed through a PIL. For example, there was a case about pollution in the river Ganga. It was called the MC Mehta versus Union of India case. It was about the fact that the government is not making enough efforts to safeguard Ganga from the ongoing polluting activities. There was another famous case which led to Vishakha guidelines. It was Vishakha versus State of Rajasthan, in which the Supreme Court gave guidelines for prevention of sexual harassment at the workplace. These are just some of the few examples of a lot of cases filed in the courts through PILs. Now, the number of PILs that have been filed in India have increased over the past few years, and there are many reasons for it. First, the Indian Constitution has things such as fundamental right, directive principles, which allow the people to question the government. Fundamental right, directive principles, all these are promises made to the people. People are told what the government will do for you. And if the government is not doing that, they can go to the court. So, these things allow the people to actually increase, or to have increased confidence, and to go ahead and file a case in the court. Second, India also has a lot of different types of laws. Many of them are progressive, but many of them mean they are changed with the time. But many of them have not been very progressive. Many of the laws in India are still very old. The government is not trying to change them. So against that also, a lot of people have been going to the court and filing PILs. Not just this, the other problem is with the concept of locus standi. As I told you earlier, locus standi means if you are connected with the case or not. Since the concept of locus standi has been taken away in the PIL, that means that a lot of people are now filing cases in the court just because they want to see how it feels. इंडिया में ये भी है ना कि even if you are not concerned with the case and you are allowed to file a case, there are many people who just want to file a case to see how it works, to see how it looks. In the Constitution of India, we have been given a lot of rights: the right to life, the right to free legal aid, right to education, etc. However, many of these are directive principles. Many of these are not legally binding. And that creates a very difficult situation for the government. These are just, many of these are just directive principles, so the government cannot be forced to accept that. But there are many people who have been filing cases in the court just because they want the government to have a look on that, and they just want to make sure that they also fulfill this formality of filing a PIL, because everyone wants his or her shot to fail. Everyone wants to see if something good can come out of it. A PIL can be filed in the Supreme Court, in the High Court, or in the Court of Magistrate. Again, I have repeatedly been telling, when you file a PIL, the court decides whether they want to hear the case or not. It is not compulsory whether they will hear the case. They think you are just wasting their time, they will not hear the case. As I said, the court must be satisfied that the matter is important and it is in the interest of the public. A PIL also can be only against public authority. PIL can only be against a public authority. The PIL cannot be against a private citizen. Someone who is not a government, against them PIL cannot fight. The PIL can only be against a public authority, like central government, municipal authorities, police. The definition of state that is given under Article 12, that state definition is to be used. So anyone who represents the government, working on behalf of the government, against them only you can file the PIL. The next part of the chapter is curative petition. As someone told me, pointed out in the chat, I think who pointed out? Chandra pointed out in the chat that Nirbhaya culprits also filed a curative petition. A curative petition is in the news. Okay. Chandra has a question. PIL are also represented in Lok Sabha. No, PILs are cases that are filed in the court. It has no connection with the Lok Sabha. Manish is saying if it is not in constitution, then can we remove PIL without amendment? No, see Manish, PIL is introduced by the Supreme Court, so only Supreme Court can remove. Government cannot remove. Now, there is a concept of curative petition. How does it work? Let's say you filed a case in the Supreme Court gave a decision and you're not happy with that decision. If you are not happy with the Supreme Court decision, the first step that you have is, so after Supreme Court gave the decision, the first step is to file a review petition. Review petition means you request the Supreme Court to review the order or to see the order again. Even if that is not accepted, or if you lose that also, after that you file a curative petition. Curative petition is filed if you request to the court to hear your matter again, not for mercy, but if you think some new fact has come up in the case. Some new fact has come up, some new discovery has come up, only then you can file. So Supreme Court decision, then review petition, and then the curative petition. After curative petition also is rejected, then you can only go to the President of India asking for the mercy petition. That is what the curative petition is. Now, the concept of curative petition started in the year 2002. The objective is that if something wrong has happened, if proper justice has not been done, if a proper process has not been followed, then we should have an option to reverse it. That is why curative petition is used. Now, curative petition has a background in Article 130. Article 137 simply says that the Supreme Court of India can reverse its order also if they think that the previous order was not fine. The law is curative petition can only be filed within 30 days of the judgment. Supreme Court judgment, whenever it came, within 30 days, the curative petition has to be. Again, this is not a petition for mercy, it is a petition to request a court to look into the matter again because some new fact may have come up. It depends on the court whether they want to accept this or not. If the court thinks you're just wasting their time, it is not worth it, and the court can reject it also. It is very rare that the court accepts it. The curative petition is first given to the bench of 3 senior most judges of the court and the judges who gave the judgment. Then they decide if the matter is to be heard again. 3 senior most judges and the judges who gave the original decision. They are the ones who decide whether they want to hear the matter again. If they decide that yes, we want to hear the matter again, then the same judges who gave the original decision will hear that matter. That is what curative petition is. As I said, curative petition has to be for a specific reason. It has to be because some new fact has come up and not just because we want mercy. There have been many times that curative petitions have been filed and Supreme Court has actually imposed fines on the people for wasting the court's time. If curative petition is accepted, usually curative petitions are heard inside the chamber of the judges. So chamber means inside the office cabin of the judges and not in the open court usually. As I said, if the bench is unhappy, if they're irritated that the time is being wasted, then they can impose a penalty also on the petitioner who has filed a curative petition. This brings me to the end of this class and the end of this mini series. Don't forget to like the video, comment what you liked, share it with your friend and subscribe to the Gradeup IAS YouTube channel. I hope this 5-chapter mini series was helpful for you. We have covered the entire higher judiciary and you would not need to study anything else in higher judiciary to solve any question in the examination. For preparing for the IAS examination 2021, 22 or 23 attempts, join the Gradeup IAS subscription. You get over 500 live interactive classes, over 500 notes, mock tests, PDFs and a lot. You have the option of joining any of these courses, 21, 22 or 23, or you can renew your EPFO course as well. Get access to all running and upcoming courses, structured study plan, expert faculties, best study material, PDF quizzes and lot. These are your faculty members who will be teaching you the different subjects. If you course, I will teach you polity, governance, and international relations. We have subject experts for all the different subjects. I'm sure you would have attended their classes and you know how they teach. A lot of new teachers have also come up. Many of them are their state-specific experts. Many of them are experts of their own subject. You're also on Telegram. The channel is public. Its name is Gradeup IAS Preparation. Join that to get free study material and short. This brings me to the end of this chapter. Thank you so much for joining in, guys. I hope you enjoyed the mini series. Do download the Gradeup app and make sure that